Hi, my name is Charles Ratuno, and this is the second part of your new teacher seminar, Navigating the Laws of Education. As new teachers, there's a lot of information regarding laws, regulations, and policies enacted at the state or federal level regarding the educational system. It's important for teachers to be aware of educational laws for several reasons: legal compliance, student protection, equity, inclusion, special education, accountability, parental communication, professional development, and conflict resolution. There's a lot of different laws out there. There's a lot of different policies out there. These are just to name a few. Today, we will review these six cases and relevant law cases to understand how these laws may apply to the educational profession. First Amendment was enacted on December 15th, 1791. Safeguards fundamental freedoms and principles such as freedom of press, free speech, religious freedom, and freedom of assembly. It prevents the government from infringing upon these rights, and schools can place limited limitations on free speech that disrupt the educational process or promotes harmful behavior. Free speech in schools is a balancing act, and we can see examples of this in the following related cases: Tinker versus Des Moines Independent Community School and Pickering versus Board of Education. In 1965, three students wore black armbands to show their disapproval for the Vietnam War. The question then became, was this an expression of free speech? And if it's applied within public schools, do schools have the authority to limit student expression through restrictions? The school had only recently implemented the rule specifically against wearing armbands, leading to the suspension of these students. The authorities didn't aim to ban all politically or controversial significant symbols, and evidence in the case showed that other schools in the district displayed buttons related to political campaigns and even displayed the Iron Cross, historically linked to Nazism. The directive against wearing armbands, however, was not applied to these instances. Instead, it specifically addressed the use of black armbands to show their disagreement in the country's involvement. The case established that schools cannot censor or penalize student expression solely due to disagreement with the content. It set the standard for good schools can only restrict speech if it's a valid expectation of significant disruption to the educational environment. Teachers' rights, we have Pickering versus Board of Education. Marvin Pickering is a teacher at Lockport High School in Illinois, and he submitted a letter to his local newspaper disagreeing with the school board's financial decisions. As a result, the school board fired Pickering. The letter expressed concerns about resource allocation, potential waste, and impact on education. As a science teacher, he felt it was more important to allocate resources to his classroom and his students rather than build a new football stadium. So the legal question posed was the district's termination of Pickering's employment in violation of his First Amendment right? And we see a contrast between this and the previous case, which was against student rights, and now we see this as a local government against teachers' rights. Supreme Court agreed with Pickering, finding that his letter was not harmful to the school or workplace, as the responsibilities of his job were not a matter of importance. The school district did not provide adequate evidence showing that his speech could cause potential harm or concern. And this case confirmed that public employees retain their First Amendment rights upon entering government service, but these rights must be weighed against the government's valid interest as an employer. The case underscored the requirement for government employees to provide substantial and explicit rationale for limiting their employer's speech. Next law we're looking at is the 14th Amendment, enacted July 9th, 1868. It ensures equal protection under the law, prohibiting states from discriminating against any group. It also mandates due process before depriving a person of property, liberty, or life. While originally aimed at protecting these rights for former slaves, the amendment has become a cornerstone of civil rights law, addressing citizenship, equality, and fair legal protections for all individuals within U.S. jurisdiction. The Equal Protection Clause mandates that schools cannot engage in discriminatory practices against students based on attributes like race, gender, religion, or ethnicity. The Due Process Clause safeguards students from arbitrary violations of their rights, necessitating that schools adhere to established and equitable procedures when making decisions that affect a student's education or when administering disciplinary measures. As previously mentioned, Pickering versus Board of Education, the Supreme Court was considering whether the firing of Marvin violated his free speech. The court's decision emphasized the balancing of his free speech rights against the government's interests as an employer. The Due Clause and the Equal Protection Clause within the 14th Amendment was used to apply the Bill of Rights, including the First Amendment, to state and local governments in a concept known as incorporation. Because of this incorporation, the Bill of Rights was applied to state and local governments, as in the case of Pickering versus Board of Education, as well as federal governments. So there's some overlap between that case and the multiple laws involved. Additionally, we have Brown versus Board of Education of Topeka, which we can review here. And discrimination and equitable actions, Brown versus Board of Education of Topeka is the name for 5 cases that were brought together and taken to the Supreme Court. These cases were brought by black families who wanted to end the separation of schools based on skin color. The question posed, was the Board of Education violating the 14th Amendment by discriminating and segregating based on race? All the judges in the Supreme Court agreed and that separating schools and public schools based on race was illegal and fundamentally unfair. Justice Warren led the court's decision and said that the idea of having separate schools for different races, but treating them as equal, which had been allowed in a previous Plessy versus Ferguson case, was not acceptable in a publicly funded education institution. The Brown versus Board of Education ruling was a pivotal moment in the fight for U.S. civil rights. It stated that segregating public schools was against the law. It led to campaigns to desegregate schools and other public places nationwide. The decision went beyond education, challenging racial segregation in all different areas of public life and inspiring the civil rights movement. Despite initial resistance, it sparked legal and societal changes that aimed to achieve equality and eliminate racial discrimination. The court famously stated, "We believe that in the area of public education, the practice of separating students based on race and treating them as equals has no basis. Having different schools for different races is by nature unequal. As a result, we declare the plaintiffs and others in similar situations are being treated unfairly to the separation they're experiencing. This goes against the 14th Amendment promise of equal legal protection." The Fourth Amendment was acted in December 15, 1791. It provides protections against sieges and searches by the government and established a requirement for obtaining warrants based on probable cause. Its application in the school context is somewhat different than other settings due to the unique nature of the school environment and need to balance students' rights with the school's responsibility to maintain a safe and orderly atmosphere for learning. Schools have a unique responsibility to maintain a safe, productive environment, which can sometimes justify searches with a lower standard of suspicion than required for law enforcement searches. An example would be in the case New Jersey versus TLO, under student and conduct discipline. A female student in New Jersey was caught smoking by a teacher in the bathroom. The assistant principal took her to his office and found cigarettes in her purse. During the search, cigarettes were discovered, but also evidence that she was involved in dealing drugs. TLO was subsequently charged with drug possession and intent to distribute. Does the Fourth Amendment's protection against searches conducted by school officials in public schools? The court ruled that while students do retain some Fourth Amendment rights, searches by school administrators or officials is less strict compared to searches by law enforcement. School officials can conduct searches if they have a reasonable suspicion that the search will uncover evidence in a violation of school rules or the law. Standard takes into account the special circumstances of a school environment and the need for swift action to address potential disruptions. NJ versus TLO created the rules for how school officials can search students in public schools. This decision found a balance between students' rights under the Fourth Amendment and the school's need for safety. It explained that although students do have Fourth Amendment rights, these rights are not as strong in school because of the special responsibilities assigned to the administrators and Board of Education. Title IX of Education Amendments of 1972 was enacted on June 23, 1972. Title IX is a federal law in the United States that disallows discriminating on the basis of sex in school programs and activities. The key principle is to ensure that individuals are not discriminated against or excluded from participation in educational programs or activities based on their sex or gender. The law applies to a wide range of educational activities and areas, including admissions, athletics, education programs, sexual harassment, pregnancies and parenting, as well as financial assistance. Davis versus Monroe Board of Education is a related case involving Title IX. Under school safety, LaShonda Davis was a 5th grader at a public school in Georgia. She experienced sexual harassment from a male classmate, and the school took minimal action to address the situation. The harassment included inappropriate touching, sexually explicit comments, and other offensive behavior. Despite repeated complaints to school officials from LaShonda's mother and the student herself, now the question becomes, can a district be held liable under Title IX for monetary damages in cases involving student-on-student sexual harassment? The Supreme Court, with all judges agreeing, sided with LaShonda Davis. They established that a school district can be legally responsible for paying damages under Title IX when it purposely ignores known instances of severe, widespread, and clearly offensive sexual harassment. Davis versus Monroe County Board of Education set a significant example for handling sexual harassment cases in schools according to Title IX. It made it clear that school districts are held accountable and stressed the urgency for schools in preventing and dealing with student sexual harassment. As a side note, It's important to recognize the date of this case and infer what it might have happened in modern times, as New Jersey, where we all teach and we have our licenses, has adopted different forms of anti-bullying laws. Most recently, the Anti-Bullying Bill of Rights. In this specific case, there is a publicly available HIB harassment intimidation form number 338 that parents can fill out if they are concerned about their child being a victim in a harassment case. This form triggers an investigation which has to be completed by multiple school administrators within 10 days of being reported, at which time it will be considered founded or unfounded. Respectively, we cannot assume how this outcome would have changed if it was in modern times, but it does provide insight how seriously states and school districts are taking the matters such as harassment and bullying, in their day-to-day activities. Individuals with Disabilities Act Education Act, IDEA. It was enacted in 1990 as a federal law to ensure that students, including those with disabilities, have access to free and appropriate public education, FAPE, accommodating their individual needs. It encompasses various disabilities such as learning disabilities, intellectual disabilities, autism, speech and language issues, emotional and physical disabilities. A core feature is designing a personalized education plan called an IEP for every qualified student with a disability. It applies to students from birth until age 21, guaranteeing suitable early intervention services and seamless transitions as they move from early childhood programs to school-based services. The primary goal of IDEA is to ensure that students with disabilities have the opportunity to receive high-quality education that accommodates their needs, including preparing them for post-public education for employment, independent living, and potential future educational opportunities. The related case is Andrew F. Douglas versus the Andrew F. versus Douglas County School District in 2017. Andrew F. is a student with autism who attended public school in the Douglas County School District in Colorado. His parents became dissatisfied with his progress and his IEP, so they enrolled him in a private school. They then sued the school district, arguing it had not been provided a free and public education as required by IDEA. Did the school district meet its obligation to provide a student with disabilities a fair and public education under the IDEA? The U.S. Supreme Court unanimously supported Andrew F., stating that under the IDEA, schools must offer students with disabilities an educational plan that is reasonably designed to help them make suitable progress considering their individual circumstances. After moving Andrew to the private school, his progress increased substantially within the domains of behavior and communication, with being able to communicate using words, gestures, and pictures. This case created additional clarity and provided strength within the legal standard for enabling students with disabilities a free, appropriate public education under IDEA. So communication is key. That was a lot of information, and we have a lot going on as new teachers coming into the brand new school year with a lot of changes in the building. And it's really important to understand the ins and outs of these state and federal laws, and it can be challenging, and I'm sure it can feel overwhelming. So let's take a moment and use this easy to remember acrostic anytime you are unsure about a situation. All right, so stop, S, pause, take a moment, assess the situation. Right? Take a look and listen and digest what's happening. Ask a colleague, union representative, administrator, or central office personnel for assistance, advice, or suggestions. If you think there is a law that you need to be enforcing, protecting, or potential violation of, ask someone. Right? Everyone's here to help you, and the goal is to provide education. So everyone's on the same page when it comes to concerning or unknown situations. Once you have the information from your colleague or from an administrator, follow through with the plan to help solve the situation. And then at the end, evaluate by reflecting on the situation, recording any important information in writing for future knowledge. All right. It's always important to document your information. It sometimes is required by law, especially in the case of bullying situations. And it's also good because after teaching for 10 years, I look back all the time and say, what did I do when that happened? When that parent emailed me, how did I handle that IEP? What was different about this situation compared to my situation? And I find myself remembering, wow, that's right. I forgot about this, and that made sense. And I can take that experience and either apply it and use it with discretion on new experiences or challenges that may come up. So any questions or any comments, feel free to stay, hang out, ask questions, raise your hand. Of course, if you have any other questions that come up or if you need some support, like I said, if you need to ask someone something, I may not know the answer, but I can help you find the answer. Send me an email and I'll be happy to respond. Thank you so much.